Good afternoon, sir. Can you see and hear me?
Yes, I can. Thank you.
Thank you very much. Mr. Smith, I'm going to now take you to advice that was written by Simon Clarke. Can we please... Actually, sorry, before I get to that, you mentioned before lunch your move from Cartwright King to your own firm.
Yes.
We have email correspondence from yourself in 2019 from a Cartwright King address.
Yes.
Are we right in understanding that you continue to be able to use the Cartwright King email address?
That's correct. I believe that I left... Again, I can't be specific, but I believe that I left Cartwright King at the end of March of 2016. I believe Simon Clarke and Harry Bowyer remained on for a little while. And at some point, after they left, we then had access to the case management system used by Cartwright King in order that we could continue to work on an agency basis for them. And so we had email accounts, Cartwright King email accounts that we could use.
Thank you. Can we look at poll 00148720? And this is an advice on criminal applicants to the mediation scheme, the 15th of July 2014. It's another one of those advices that is written, has Simon Clarke's name at the end, 15th of July. But throughout the advice, if we scroll down to paragraph 2, for example, it says, "It is our considered view." And we see often throughout references to we. Did you have any involvement in this advice?
I'm afraid my answer has to be the same as the earlier ones. I may have seen it, I may have commented on it, I may have been asked to proofread it. I cannot state specifically that I had positive input into it.
And paragraph 2 says, "It is our considered view that no applicant guilty of a criminal offence committed against the Post Office should be allowed into the scheme. For to mediate such applications will be to leave the Post Office open to a number of alarming consequences. Those consequences include, but are not limited to, the following. The fact of entry into the scheme of itself indicates that the Post Office is at least prepared to concede that they may have erred in prosecuting the applicant. Similarly, the fact that one such applicant has been allowed to enter into a scheme sets an unfortunate precedent." It then goes on, subparagraph 3, about the threat of an appeal. Same paragraph 4. "Setting a precedent, any competent lawyer would advise a substantial concession by the Post Office." And then paragraph 3 goes on to address other risks. It says, for example, "Whilst the issue is strictly outside of our criminal purview, we feel bound to point out that the potential for adverse publicity generated by the mediating of criminal applications, and particularly where some concession agreement or payment is made by the Post Office, is inestimable." It refers to the knock-on effect. There's every likelihood that we would be required to disclose the fact and detail to others in a similar position. Similarly, a successful appeal would give rise to a considerable assessment and disclosure exercise, all conducted in the full view of the media. Over the page, please. Paragraph 5, "We can identify no proper reason for the inclusion of criminal applicants into the scheme." Were those all views that you shared at the time?
I think I accepted that as being a sensible approach.
Can we please turn to poll 00112928, page 78. So that advice we've just seen was July. We're now in November 2014. And it's an email from yourself to Mr. Parsons. You say, Andy, from a criminal perspective, we would advise as a general rule against the disclosure of any documents from a criminal file which have not previously been disclosed to the defendant during the course of the original proceedings. To do otherwise may well enable the defendant or second sight to attempt to criticise the way in which the prosecution was conducted or how the prosecution policy was applied. Clearly, such arguments in a public arena would be uncomfortable for the Post Office. We remain concerned that second sight are pushing for the disclosure of files and advise that a robust stance be taken by the Post Office in relation to all such requests. So you were concerned there about defendants being given documents that weren't relied upon in their criminal prosecution.
We are advising, as a general rule, against the disclosure of documents which have not previously been disclosed.
And is that because you were concerned about your own decisions coming under scrutiny?
No. No.
If you had made the right decisions regarding disclosure in the original trial, why would you be concerned about access to those files and disclosure from those files?
I don't think that it occurred to us that any incorrect disclosure decisions had been made at the time.
So why would you be concerned about disclosing documents from the criminal file if you had made the right decisions?
No, so the approach that Cartwright King was taking here was that if something was on a sensitive material schedule, then it ought not to be disclosed unless it was something that had been disclosed during the original proceedings.
Yes, and is that because you were concerned about the disclosure decisions that had been made in those original proceedings?
No, no.
We looked at the case of Ishak yesterday, and I think I suggested that you were perhaps taking too robust a stance on disclosure to Mr. Ishak. We see here another reference to a robust stance to be taken in respect of disclosure decisions. Were you now repeating the same errors that occurred during the criminal trials, that you were taking too robust a stance on disclosure to those who had been affected?
I didn't see it that way at the time.
Why do you think it was that after all that we've been discussing, and I won't repeat the various stages, Gareth Jenkins, new information, etc., why do you think then you were still calling for a robust stance to be taken in respect of disclosure to those who had been prosecuted?
Of course, this is in the mediation scheme, and the view that the firm was taking was that only material which would have been disclosed during the initial proceedings should be disclosed. I didn't disagree with that approach.
Yes, but that's really repeating the same point that you've already been making.
But that's my point. That's the point I can make. I didn't see it any other way.
And it isn't your evidence that you're concerned that in some way that would help somebody appeal?
No, I didn't think of that.
Can we please look at poll 00150-342? The bottom of the first page, Roderick Williams confirms there that Mr. Altman, Brian's advice is that we shouldn't engage with either of Tony, that's Sir Anthony Hooper's proposals, given the inherent risks in having a free discussion about the facts which give rise to a conviction. Do you recall Sir Anthony Hooper being in favour of including those who had been convicted, and Cartwright King and Mr. Altman forming the view that they shouldn't be?
I can recall Mr. Hooper taking the view that it should include everyone, and Brian Altman having a strong view about that, yes.
If we scroll up to the middle email, there's an email from Roderick Williams to yourself. He says, Martin, can you please give Chris Oyar a call as soon as possible. He wants to discuss how to approach Tony Hooper about mediating criminal cases, specifically those involving false accounting. Tony is not currently sympathetic to our position, so we need to work out how else we can land the points. And there is a response above from Chris Oyard, who says, "Thanks, Rod, we've now spoken, and the work that we discussed has been commissioned. Cheers, Chris." If we please could turn to poll 00150390. There is the advice, which contains a draft letter to Sir Anthony Hooper. Is that the work that had been commissioned, or was the work that had been commissioned something else?
I don't recall, but I can see that the advice starts here that we are asked to suggest the text of a letter to Sir Anthony Hooper.
Yeah, so
So it may very well be that that advice is in response to the request that has been received from the then General Counsel.
do you recall having a conversation with Chris Oyard about this issue?
I'm afraid I don't.
Were you involved in the drafting of this advice?
It's possible that I may have seen it, been asked to look at it, might have discussed it. I don't recall.
What do you think made the team at Cartwright King, including yourself, think that you knew better than Sir Anthony Hooper on matters relating to those who are convicted of criminal offences?
I don't recall thinking about whether or not we knew better than Sir Anthony Hooper at all. That wasn't my thought process.
And I think you've said that your thought process didn't involve any consideration to the effect that you wanted to prevent people from appealing to the Court of Appeal.
No, the way that I had seen this was how it had initially been put by Post Office, that they were concerned, for example, that a throwaway comment or something like that, or some attempt to reach settlement might somehow give a convicted applicant a ticket to the Court of Appeal, just inadvertently through making some form of minor concession or presenting something in a different way. So I didn't see this as trying to prevent people from appealing. I saw this as effectively trying to help Post Office protect their position.
Mr. Smith, you've used the word ticket to the Court of Appeal. Is that because you have in mind the next document that I'm going to take you to, which is poll 000668872? And this is a file note from your file, May 2015, relating to Seema Misra's case.
Yes, ticket to the Court of Appeal was a phrase which we used internally on a number of occasions.
Can you assist us with this note? It says, there's a summary, Andy Parsons, MJS, that's yourself, explaining position, issue redisclosure. Detail, telephone call, Andy Parsons, MJS explaining position, issues redisclosure. Clearly unhelpful if the Post Office proceeds with draft CRR responses. Those are, I think, case review report responses. Without regard to disclosure issues, may damage the Post Office's integrity. Disclosure may give Misra tickets to the Court of Appeal. Need meeting possibly of Thursday. Any chance can keep moving with the reports being watered down. You would not advise that. The problem will arise if you need to make disclosure and did not set the record straight when had the opportunity to. Also, there is the Criminal Cases Review Commission in the background. Were you and Mr. Parsons in May 2015 concerned about disclosure to Seema Misra because it may give her a ticket to the Court of Appeal?
No, the I can't quite remember the timeline, but when we started the file review process, Mrs. Misra's case was one of those which we reviewed, but we were only able to review it from a very limited amount of information. I don't think the legal department could find the file at that point. At some point, the file did become available. Now, I don't know how that fits into this timescale, but at this point, Bond Dickinson were wanting to push ahead with responses in the mediation scheme. I assume that there was some sort of time frame within which they were trying to work, some sort of agreed time frame. They were wanting to draft responses, and I took the view that it's unhelpful to draft those responses without having regard to any potential disclosure issues, because if those responses are inappropriate, either because something needed to be disclosed which wasn't, or alternatively some sort of comment was made which was by way of concession, but an inappropriate concession, either way that could be damaging to Post Offices Limited's integrity. I was very aware that whatever was said in their CRR response could give any applicant the opportunity to approach the Court of Appeal. You'll see from the second paragraph here, the question I am being asked by Mr. Parsons is there any chance we can keep moving on these CRRs with them watered down? In other words, rather than wait for perhaps Simon Clark or Harry Bowyer to have finished a review of the case or some information, can they just proceed with that response watered down? I was against that, because I took the view that if they did so and disclosure was appropriate, and it hadn't been included, then that would be damaging. If disclosure should have been provided and wasn't, there would be adverse consequences for that if the record was not set straight when Post Office Limited had the opportunity to do so. And I was also telling them, look, the CCRC are watching you. They are in the background watching what you do here. So I was very aware that the response to the CRR was something which had to be got right, and I wasn't prepared to allow Bond Dickinson to water this down. I was very aware that if disclosure needed to be provided, then it should be provided when there was the opportunity to do so. Otherwise, I could see there being all manner of repercussions for Post Office Limited.
It might be suggested that the reference in that first paragraph to disclosure giving Seema Misra a ticket to the Court of Appeal is that you were concerned, together with Mr. Parsons, about Mrs. Misra being able to successfully appeal in the Court of Appeal.
If someone could appeal, then so be it.
Was there a concern at Cartwright King, and a concern held by you and others, that there may be successful appeals to the Court of Appeal in cases that you prosecuted?
No, I wasn't concerned that there would be successful appeals at all to the Court of Appeal. That wasn't something that concerned me. My concern was that Post Office, in embarking upon this mediation scheme, should not be making small concessions which appeared trivial but could actually be presented in a very different way, which could actually then give someone the opportunity to pursue an appeal. What we were seeing during some of these mediations were that some convicted applicants were actually putting forwards very different facts to the actual information that they'd relied on, for example, by way of mitigation following a guilty plea. So we were alive to some of these points. But no, in relation to Mrs. Misra's case, as it says in my second paragraph here, I would not advise proceeding with a CRR watered down. A problem would arise if disclosure needs to be made and we did not set the record straight when we had the opportunity to do so. It was important that it was correct.
Given everything that you had learned over all of those years that we've been discussing in your evidence, all of those various developments year after year after year, by 2015, didn't you think that you should do everything you possibly could for somebody like Seema Misra in relation to a potential appeal to the Court of Appeal?
Well, at this point in time, her file, I believe at this point in time, her file had been reviewed. I think the initial review was on the basis of, I think, just the judges summing up to the jury, but the file subsequently became available, and that was reviewed, I believe, by Mr. Cluck. And I'm unable to recall, actually, whether disclosure was sent through to her of the second site report and the Helen Rose report. I'm afraid I can't remember that.
Issues with Gareth Jenkins?
There was no reference to that in the letters which were sent out.
Various additional bugs, errors and defects?
Again, there was no consideration of disclosing that. The second site interim report made reference to 2 bugs, and we had the Helen Rose report. We were then really looking forwards and gathering information ready for the instruction of an expert.
Thank you. So those are all of my questions for Mr. Smith. We have a number of questions from core participants. The first on the list is Ms. Watt on behalf of the NFSP, who will be principally asking questions relating to the Scottish cases.
And as I understand it, Ms. Waters has a 15-minute allocation. Is that correct?
Yes, that's correct.
Fine. Thank you. Over to you, Ms. Scott. Ms. Watt, sorry.
Thank you, sir. Good afternoon, Mr. Smith. I think I'm just behind Mr. Steve.
I can just about see you, yes.
Thank you. You can see me. I want to ask you some questions about the period in 2013 when you're dealing with what's happening in the Scottish prosecutions. And I'm not going to take you to a witness statement, but at paragraphs 132 to 134 of your witness statement, you refer to 2 meetings in Scotland in September and October 2013, which you attend with Simon Clarke and Jarnell Singh, together with the Post Office's Scottish solicitors, where you say you met the Procurator Fiscal. And you say those meetings arose because there was a concern that there was to be a termination of Scottish criminal cases on the basis that Horizon was allegedly unreliable.
Yes.
Okay? Now, by this time in 2013, it's correct to say, isn't it, that you knew Gareth Jenkins had been discredited as an expert witness?
Yes.
Not least because your colleague Simon Clarke had written advice for the Post Office about the issues with and the use of Mr. Jenkins as an expert witness. Isn't that right?
That's right.
And at that time, you also knew of at least 2 bugs in the Horizon system, didn't you, from the Simon Clarke advice and the second site interim report?
Yes.
And while your interpretation of the second site interim report is not much to see here, you would agree that in fact it did raise questions about Horizon and a lack of disclosure to sub-postmasters in their defence at criminal prosecutions.
Yes.
You also knew what was in the Helen Rose report, didn't you?
Yes, I believe that's right at that time.
And you knew by the time of the meeting in September 2013 with the Procurator Fiscal that prosecutions in England had been paused by Susan Crichton because of all of these concerns, didn't you?
New prosecutions had been stopped, and existing prosecutions were being looked at on a case-by-case basis by Mr. Clarke, I believe.
But nonetheless, you went to Scotland with your colleague Simon Clarke and Jarnell Singh from the Post Office to try to prevent the Crown Office and Procurator Fiscal Service from terminating criminal prosecutions on the basis that the Crown Office was questioning the reliability of Horizon evidence for Scottish prosecutions, didn't you?
Well, we were asked to go, I believe by Susan Crichton, and there was a suggestion that the Procurator Fiscal was considering terminating all of the prosecutions. The suggestion that I believe Mr. Clarke made was that they be adjourned pending a new expert, and the Procurator Fiscal's office was actually content to adjourn those cases to await a new expert. It was actually quite surprising because in England and Wales, it's unlikely a court would have entertained an adjournment of several months to get a new expert. So the position in Scotland, I understand, was quite different.
Well, I think it was explained to you why that was. I'm going to take you to some documents that might help with that. First of all, can we go to Paul 00139902? That's a telephone note from the 12th of July 2013, and you're on a call with a representative of the Crown Office.
Yes.
And this is you, sorry, I'm just, go to the correct one for me. 29th of July 2013. And this is you on a conference call with a representative of the Crown Office and along with one other from Cartwright King. Would that be Simon Clark?
It could be.
You explained that your law firm carried out prosecutions on behalf of the Post Office south of the border. That you had been told the Horizon Horizon system was foolproof, but a report has been prepared by a body called Second Sight, which has revealed some bugs in the system. There's a second report, which the Post Office, are calling the Helen Rose report. It's an internal report and it's critical of the system. There are times when the system does not differentiate between computer-generated entries and manual entries. If we go on to the paragraph, Martin explained that Second Sight was basically a committee set up in response to complaints by some sub-postmasters. The Post Office contracted with Second Sight to produce this report following complaints made by sub-postmasters to various MPs. Would you accept calling it a committee set up in response to complaints by some sub-postmasters actually a minimisation of what Second Sight was and what you already knew it was uncovering?
I don't recall using those words.
It is a minimisation, isn't it?
Well, Second Sight is not a committee. Second Sight was a limited company. And it wasn't a committee set up in response to complaints. Second Sight was engaged to look into issues that had arisen. So I think that part of the notes of the conversation is incorrect.
You go on, the paragraph that starts, a number of defendants have had inexplicable losses, that paragraph. Martin explained that in some cases the Post Office, they've lodged expert evidence which said there was nothing wrong with the Horizon system. This expert was a man named Gareth Jenkins, one of the architects of the system from Fujitsu. It's clear from the report that Gareth Jenkins, employed by Fujitsu, was aware of bugs in the system. One in particular has created false information, but this was not mentioned in his reports. Would you agree that, taking account of the Simon Clark advice and all that was known by that time in relation to Mr. Jenkins, that is a minimisation to the Crown Office of the position?
No, I don't. I think that sets out the position. Mr. Gareth Jenkins, one of the architects of the system, it's just moved on my screen. He'd said that effectively there was nothing wrong with the system. I think that explains the position with Mr. Jenkins.
Can we now go to Paul 00139906? That's a telephone note of the 14th of August with you and the Scottish solicitors. And if we scroll down 5 paragraphs down, Martin mentioned Susan Crichton, who is head of law at the Post Office. She has now agreed to stop issuing summonses in relation to Post Office cases because of the mess that they are in. And you go on to say in the paragraph, Martin explained the lines of communication have not been very effective. Even legal were not aware of the Helen Rose report initially, only aware of the Second Sight report. And there's then a discussion about the central hub that you've been discussing with
Yes.
Mr. Blake. If we can scroll down to the second page, you're going on to discuss Brian Altman, then QC, now KC, dealing with the review cases, which include pending cases. And you go on to say, Martin explained they were hoping to meet with, that'd be Brian Altman, during the week of 27th August, and the likely outcome would be that Post Office would agree to obtain an expert report. You didn't know at that point if the Post Office would in fact obtain an expert report. This was just your thinking, wasn't it?
In the second paragraph there, the likely outcome would be that the Post Office would agree to obtain an expert report. So it was expected that the Post Office would. This is also mid-August, when I think in the July meetings, Mr. Clark had advised that Post Office would need to obtain a new expert, and I understand that it was around this time, or probably just before this time, that inquiries were being made with regard to potential experts. So that was very much the intention.
Okay, a final document to go to for just now. Can we go to Paul 00139879? This is the meeting note where you go to meet the officials at the Crown Office and Procurator Fiscal Service, first meeting your solicitors on the 4th of September, and then the Crown Office the following day. You, Simon Clark and Jarnell Singh. So quite a bit of effort being put in there. Wouldn't you agree to go, all of you, to Scotland to do this?
Well, I think Mr. Singh flew up from London, and myself and Mr. Clark went on the train from Derby.
If we go to that document, I think I gave the number. Yes, there we are. So if we go to the second page, we're at the 5th of, sorry, I think, third page, I think it is, sorry. We're there. Paragraph 9, it was very plain from the PF's current position on Paul that all such cases should be terminated. So that was the main concern for Post Office, wasn't it, that they were going to terminate the cases?
Yes, it was. And I can recall that in London, when myself and Simon discussed it, the legal department were quite concerned that there could be some form of announcement with regard to the integrity of the Horizon system, which could have implications for Post Office.
Yes. Well, if we just scroll down to page 4. Whilst under the English, this is the Crown Office representative, disclosure is to a large extent guided by the defence response and a likely plea. In the Scottish system, disclosure rules dictate that even where the accused has made unequivocal admissions to auditors or interview, disclosure relating to a corroboration fact occurs ab initio, that's from the start. This situation arises because in many cases the PF does not know what the defence is going to be, and it continues on. If the question is, if one piece may be unreliable, that's of the evidence, then it does not qualify as independent, reliable corroboration. Okay, so that's what you were being told. Now, if we scroll down to paragraph 13, Simon Clark then outlined the proposed instruction of independent expert witnesses, and at paragraph 14, a new understanding on the part of those who were there from the Crown Office. This amounted to a departure from his starting point that all Paul prosecutions were to be terminated. Indeed, matters went much further for discussion and then focused on how the present prosecutions were to be advanced. This recommendation amounts to a complete reversal of the PF's original position. I just want to ask you some questions about that. Did you understand, if we take all that has been discussed about what you knew regarding Simon Clarke's advice, the Second Sight interim report, the Helen Rose report, decisions regarding English prosecutions, which aren't mentioned anywhere there, that what you were being told about the disclosure and evidential requirements were actually a higher bar in Scotland compared to what you were used to doing in the courts in England in your private prosecutions?
I don't think I thought of it in terms of a higher bar. I just considered that it was a different legal system and that it would be helpful for an expert report to be obtained to assist. Because at this point in time, whilst you mention Helen Rose, the Second Sight report, the number of issues at that point in time were actually, on the face of it, relatively small. I mean, clearly a lot more has come out since, but at that point in time, the issues appeared to be relatively narrow, and so the approach that we had in mind was to get an expert report.
So you're very pleased to note at the end of that meeting you've achieved your objective?
That is what the note says, yes.
And taking all of that together, I'm suggesting to you that you were, at the very least, disingenuous in the way you sought to persuade a Crown officer, a representative of Scotland's most senior law officer, the Lord Advocate, not to terminate all such prosecutions.
No, I don't agree. I'm sorry.
And that what you were doing was to seek to get the entirety of Scotland's criminal justice system onto the side of the Post Office and not terminate the prosecutions of sub-postmasters in Scotland.
No, well, I don't think at this point in time we actually knew what the pipeline of cases was there. This isn't a case of just close every prosecution down. Some of the cases being investigated were not actually, may not actually have been of sub-postmasters or postmistresses. They could have been of counter-staff, and the victims may have been the sub-postmasters or postmistresses. So the approach that we were taking was that it would be appropriate to get an expert report to actually completely deal with the issue of the integrity of the Horizon system so that these issues could be considered.
Sir, I see I've gone just over my time. I've got another couple of questions just to finish off, if I could be allowed. It'll only be maybe another 1 to 2 minutes.
Well, 1 to 2 minutes, and then I'll use my gavel, so to speak.
Okay. This meeting is equivalent to going to, for instance, a meeting with the Director of Public Prosecutions, trying to persuade the DPP to continue with prosecutions when you knew Horizon and the expert witness were unreliable. Do you understand how serious it is to have done that?
I'm sorry, I don't agree. We went to meet with the Procurator Fiscal's office at the request of Post Office with the Scottish lawyers there to explain what Post Office was proposing to do.
Are you aware of the fact that 6 Paul criminal cases in Scotland have this week been quashed by the High Court of Justiciary in Edinburgh, and at least 2 of these cases are ones where pleas and cases took place in the courts in 2012 and 2013, before your meeting, but not far before your meeting? What are your reflections on the quashing of those cases?
My reflections on the quashing of those cases are exactly the same as the reflections I have on the quashing of any other cases. This has turned out to be an absolutely horrendous situation for all those victims, and I'm pleased that they have been quashed.
There you are, Ms.
Thank you,
Watt.
sir. Yes, that's me. Thank you.
Can I'm just making sure I've got these dates right. These meetings in Scotland took place in September 2015. That's right, yeah?
2013.
13. Right, then that's why I'm confused. That's fine, 2013.
So we're going to be hearing from Mr. Maloney next, but perhaps could I just spend 5 more minutes on that particular document? We do have time. I went under time.
Everybody is very persuasive today about getting more time out of me. 5 minutes, Mr. Blake.
Thank you very much. So can we just bring that document back onto screen? it seems as though there was a pre-meeting on the 4th of September amongst yourselves and lawyers from BTO.
Yes,
And
that's
then-
correct.
And then if we turn to page 3, there is the meeting with representatives from the Procurator Fiscal Office on the 5th of September.
That's correct, yes.
And amongst those representing the Procurator Fiscal are somebody called Paul Mealy, who is the PF Deputy, correct?
The depute, yes.
Depute. And it begins there, paragraph 8, that he informed the meeting that his role was to formulate a policy recommendation and to put it forward to the Procurator Fiscal. And then we see at paragraph 9, it was very plain from the outset that the Procurator Fiscal's current position on post office prosecutions was that all such cases should be terminated. So you went into that meeting aware that the Procurator Fiscal wanted to terminate post office prosecutions.
Yes.
If we turn over the page to paragraph 12, it says, and this is the first meeting with the representatives from the Procurator Fiscal's office. The previous meetings we've seen are only with solicitors from BTO. Paragraph 12 says, this brief overview of the Scottish system provided the foundation for the discussion which followed. SC, that's Simon Clarke, provided the meeting with a broad overview of the, I think that's Horizon Online difficulties, in brackets, absent any direct or indirect reference to the role of Gareth Jenkins or Fujitsu. Just pausing there, why did Simon Clarke provide the meeting with an overview, first of all, of Horizon Online rather than generally Horizon issues, and secondly, why was it absent any direct or indirect reference to the role of Gareth Jenkins and Fujitsu?
I don't know.
And is it therefore, following that conversation, a brief overview which gave a broad overview and excluded quite relevant matters relating to Gareth Jenkins and Fujitsu, that the Procurator Fiscal's decision was a reversal of their original position? That's paragraph 14. As a result of this new understanding on the part of Mr. Mealy and his colleague, Mr. Mealy agreed that his recommendation would be that each case be reviewed separately and a decision taken on the facts of the individual case. And the final sentence there, this recommendation amounts to a complete reversal of their original position.
Yes.
So it seems as though that reversal took place after what is described in paragraph 12 as essentially a very limited reference to the issues with Horizon. Is that your recollection of what happened at that particular meeting, the second meeting, the 5th of September meeting that involved representatives from the Procurator Fiscal?
I struggle to recall the entirety of the meeting. I was there taking notes. And if Mr. Clarke has put there that he didn't mention Mr. Jenkins, then that will have been correct.
Paragraph 12, was this note drafted by Mr. Clarke, do you believe?
I believe he was typing it on the train on the way back from Scotland, but he would have had access to my handwritten notes whilst he was preparing it.
And are you able to assist us with why the words in brackets may be in a smaller font or appear to be in a smaller font? Might they have been typed later?
I don't know, I'm afraid.
Thank you very much, sir.
Right. Mr. Maloney, it is, by my reckoning, 14:38, so you can have 22 minutes, and then we'll have a break at 3 o'clock.
Thank you, sir. I'll try and be less than 22 minutes, but I agree it is 14:38. So, Mr. Smith, you described going to see the judge in private in Birmingham Crown Court in the case of Samra on the 1st of July 2013.
I can't confirm that's the date, but I do recall going and seeing the judge in private with Mr. Clarke.
It was listed for trial that day, wasn't it? It doesn't matter if you can't remember.
I don't think it was listed for trial that day.
Right. Well,
it-
we can establish that with Mr. Clark later anyway. But
the-
essentially, you went to see the judge because you wished to apply to withhold from the defence what you'd heard from Gareth Jenkins about the likely contents of the second site interim report after what he had told them.
I think that's not quite right. It wasn't what we'd heard from Mr. Jenkins.
Right.
I think it was what we'd heard from Post Office Limited
I
about there being a report
Yep.
that made reference to bugs,
Yep.
and I don't believe at that point we had a copy of that. We only knew what we had been told, and Mr. Clark and I, as you know, had spoken to Mr. Jenkins by telephone, who gave an explanation that there had been 2 bugs. So Mr. Clark decided that he, at that stage, was not in a position to properly comply with his duties of disclosure.
Yep.
Because whilst we knew some information, there was clearly more information that we'd want to know. There was clearly a report here that we did not have a copy of,
Yep.
which he thought ought to be considered for disclosure, and he was not prepared, as I understand it, to go through a trial or to commence a trial without disclosure having been properly dealt with. And it was
Right.
in those circumstances that the application was made. I don't know whether it was actually on the day of trial or a day or two before the day of trial.
Doesn't matter. But essentially, you wanted to withhold from the defence at this stage what you'd been told about what the second site interim report was likely to say about things.
I didn't see it that way. I saw it as Mr. Clark saying that he could not comply with his duties of disclosure. He was prosecuting counsel in that case, and that was his view. So
Okay.
I
Well, let's
saw it
let's
that way.
just try and develop that, please, Mr. Smith. You went to see the judge in private to make an application.
I went along with Mr. Clark's, who was making the application.
It's an ex parte application. It means the other party's not there, doesn't it?
That's correct, yes.
And your application was a public interest immunity application, wasn't it? Did you understand that?
I don't think I did at the time. I just knew that Mr. Clark was making an application and I was making notes of it.
Right. So when you say you didn't understand that at the time, do you understand that that's what it was? Do you understand now that that's what it was?
I believe that that's what it was. I don't recall it well enough, except to say that Mr. Clark was explaining to the judge that he could not disclose the correct material at that particular point in time. Not that it would not be disclosed, it was just that he wasn't in a position to discharge his disclosure duties at that time.
I'm sorry to interrupt, but that's telling the judge what he can't do. What exactly was he asking the judge to do?
I'm afraid, sir, I can't recall.
Well, I mean, was he saying, look, I've got this problem, but that we should proceed with the trial anyway? Was he asking for the trial to be adjourned? What was he doing?
No, I don't believe that he was going to proceed with the trial.
So he was asking the judge what, to adjourn the trial or to enter a not guilty plea against the defendant? What? The judge must have been asked to do something specific.
So I'm afraid I can't remember.
Right.
I really can't remember. I remember.
I'll try and help you with your recollection, Mr.
I remember
Just see if
turning
this
up and
accords.
taking notes.
Okay, I'm sorry to the stenographer for talking over for us talking over each other there. I'll try and assist you with your recollection, okay? Because what actually did happen was that a public interest immunity application was made on behalf of the prosecution, Post Office Limited, okay?
Okay.
And you know that now anyway, don't you?
Yes.
Yeah. And you know, you've said that, of course, you practiced in defence for a number of years, but you were relatively new to prosecution, so you took Mr. Clark's advice and were guided by him as to the making of this application.
Well, it wasn't the case that I was guided by him in the making of the application. He made the application and I was there taking notes.
But you were as instructing solicitor, to all intents and purposes, Mr. Smith, weren't you? A very experienced solicitor. You were there with counsel who you worked with, hand in glove, it seems, from all the correspondence that we've seen. You were a 3 on this occasion, you were a 2. You worked together.
I was working with him on that day, yes.
Entirely. And so, did he not tell you what he was doing?
I cannot recall enough about the day, I'm afraid.
Right, okay. Well, I'll try and assist. A public interest immunity application, as a defence solicitor of some experience, is an important procedure, isn't it? Essentially withholding material from the defence which would be helpful to the defence and would ordinarily need to be disclosed. That's what it's about, isn't it?
That is a PII application, yes.
And you were aware, were you, of the important House of Lords case of H&C and the conditions it laid down for when a public interest immunity application should be made?
I can't say that I could recall that.
Right. Okay. But as a solicitor, would you know that really that it should only be made where a prosecutor has identified material that should be disclosed, but disclosure of it would create a real risk of serious prejudice to an important public interest, and the prosecutor believes that the public interest in withholding the material outweighs the public interest in disclosing it to the defence? Would that accord with your general appreciation of the rules in relation to public interest immunity applications?
I can't say that I had previously come across a PII application.
Right, okay.
So that's new to me.
But you not remembering much about this, did Mr. Clark give you any reason as to why he was making the application to withhold the second sight report? You previously mentioned yesterday something about parliamentary privilege, Mr. Smith.
I can recall a conversation that I had with Mr. Clark. I'm afraid it's all a little hazy because it's such a long time ago, but we were very much aware that the second sight report was going to be released to members of Parliament before it was going to be published generally. And I think at this particular point in time, we did not have the report, and we only knew snippets of what it was likely to contain.
Right. Did Mr. Clark say to you that one aspect of the public interest that he was asserting to the judge in his application would be the prevention of a widespread loss of confidence in Post Office?
I don't recall that being said.
Did he say that another aspect would be the loss of trust in a system operated by Post Office?
I'm sorry, I just don't recall the conversation.
Finally, just ask you, just for the sake of it, did he say that another aspect would be the prevention of journalistic speculation as to the efficacy of systems almost universally relied on by the public?
I don't recall that either, I'm afraid.
And then, finally, did he say to you that, essentially, Post Office Limited were rightly, in my opinion, very concerned at the potential adverse publicity which would inevitably have been generated by the revelation of the existence of a draft second sight report into Horizon? To permit this information to enter the public domain at such an early stage would have been to encourage extremely unhealthy and likely virulent speculation as to the content of any report, most probably in the national press. Such speculation would have seriously damaged the reputation of Post Office Limited and would have greatly undermined public confidence in both Post Office Limited and Post Office Limited systems. Our objective was to avoid such consequences. That objective we achieved with the public interest immunity application.
I don't recall that, I'm afraid, either.
If Mr. Clark had set all of those things out that I've just asked you if you remember him saying in a note of the day's hearing, would you have seen it? A note sent to Paul, an attendance note.
I don't recall seeing an attendance note, no.
Would you ordinarily have seen such an attendance note, Mr. Smith?
Sometimes I was asked to look at things, proofread them, and sometimes Mr. Clark would go through things, and other times I wouldn't. I'm afraid it doesn't ring any bells with me.
No, I don't. Obviously, you can probably see that I am actually saying that Mr. Clark did set that out in the attendance note.
I'm gathering from the way you're asking the questions that you're reading from an attendance note written by Mr. Clark, but I'm afraid it doesn't ring any bells with me at all.
Were the defence Mrs. Samra's lawyers put on notice that you were going to make a PII application?
I have no idea. I have no idea.
This was your very first PII application, Mr. Smith, either defence or prosecution, was it? In all your years of experience?
Well, I'm afraid I have absolutely no idea about this. I know that Mr. Clark was prosecuting counsel, and I don't know.
Did you have any role in notifying Mrs. Samra's solicitors that there was going to be a PII application made on the 1st of July 2013?
I'm not aware that I did.
So you can't help whether or not any notice was given?
I'm afraid I've got absolutely no idea.
Were you aware that if the prosecutor makes an application to the court without notice to the defence, because the only circumstance in which it can be done is because it would have the effect of disclosing that which the prosecutor contends should not in the public interest be disclosed, and that is a highly exceptional situation?
I'm sorry, what was the question?
Were you aware that when a prosecutor makes an application to the court, and this is under the criminal procedure rules, without notice to the defence, because to do so would have the effect of disclosing what the prosecutor contends should not be in the public interest be disclosed, that's the only circumstances in which an application can be made without notice to the defence?
No.
Are you aware of that?
I wasn't aware of that, no.
No. But an application was made by Mr. Clark, with you in attendance making notes as a solicitor of some post-qualification experience, and you went into the judge's chambers with Mr. Clark, and the judge himself was a Judge Chambers, wasn't he? Do you remember that?
I'm afraid I don't know.
And what happened was, you were to, as a PII certificate was granted. Were you aware of that?
I don't recall.
Right. And you were to inform the defence that a report had been commissioned, but you could withhold the existence of the interim report, and it was to be presented to MPs that day. And then the matter was adjourned for 8 weeks. Are you aware of that?
I don't recall that, I'm afraid.
Right. Thank you very much, Mr. Smith. So that's only 18 minutes, I think. Yeah.
Very good, Mr. Maloney. Mr. Steen, can I press you in the sense that I think you were next and you wanted 15 minutes, and if that is accurate, then we could probably slip that in before our break.
So I think it is accurate. I'll be 15 minutes, but I'd hope to be slightly less.
Right, well, even more reason for you to carry on, if you will, please.
I'm grateful. In that case, Mr. Smith, let's proceed with the questions I have for you. At the time whereby you, working for Cartwright King, were engaged on the prosecution of matters for the Post Office, do you agree that you were following the Code of Practice for prosecution advocates that was issued by the CPS?
I wouldn't agree that, no.
You weren't. What Code of Practice in relation to your prosecution work do you think you were following?
I'm not confident that we had the necessary skills and expertise to be able to follow codes. I'm afraid, as I said earlier, we're essentially a defence firm of solicitors, and it's beyond me as to why the firm decided to take on prosecution work, knowing that we hadn't been specifically trained in prosecution work. And so, whilst there may invariably be codes of practice and other requirements, I think it's difficult to follow them if you're not aware of them.
Understood, Mr. Smith, but it's you taking on the work. You are an advocate, by this point an advocate of some experience. You had qualified as a higher rights advocate well before 2010. Do you agree?
That's correct.
And it is you that is subject to the regulatory responsibilities issued by the Bar Standards Board. Do you agree? Do you agree?
I'm sorry, could you just repeat that?
You are Sorry, you're a solicitor, aren't you? So you
Yes.
are subject to the regulatory responsibilities of the issued by the SRA, the Solicitors Regulation.
Yes.
Do you agree with that? And you agree that you should work within your own field of competence? You
Yes.
also accept that?
Yes.
So when you started to take on prosecution work on behalf of the Post Office, did you consider the question of what ethical standards should apply to your work as a prosecutor?
I didn't consider that it didn't occur to me that I did not have the requisite skills and expertise for this role.
Did you look them up?
No, I didn't.
Now, in old-fashioned terms, the way that the standards applied to prosecutors used to be called a Minister of Justice. Did you consider, even in the loosest possible way, that you as a prosecutor needed to act as a Minister of Justice?
I considered that I needed to do things properly in accordance with the law, and that is what I attempt to do.
Have you heard the term Minister of Justice being applied to prosecutors?
I have, yes, now.
Right. Let me ask the question again. Did you consider that that should be the way that you should act when prosecuting?
That is certainly what we try to do, yes.
Did you think about it, Mr. Smith, that I must, when prosecuting these cases, act in a way that is bringing the highest ethical standards to apply to prosecution cases? Did that cross your mind or not?
I don't think I gave it a huge amount of thought.
So the answer is no, I didn't.
No.
All right. Let's turn to then the call that you had with Mr. Jenkins, and that was prior to then the issue of what we all call the Clark-Jenkins advice.
Yes.
Okay? Right, that call. Now, that call was recorded.
Yes.
By the time, therefore, that the call with Mr. Jenkins was recorded, do you agree that you and Mr. Clark were, at the very least, suspicious that there was a problem with Mr. Jenkins?
Suspicious, yes.
Yes, otherwise why record the call?
Oh, yeah, yes.
So this wasn't an example of Mr. Jenkins being told, by the way, we're going to record this call because we think there's a few things that are of real concern. You didn't warn him that you're about to call him.
We didn't warn him, no.
No.
And we were obviously concerned that reports that had been provided did not make reference to the bugs.
Why was it recorded?
So we could have a transcript of it for our own files.
Right. So the transcript was there and the call was there so that you would have evidence in relation to what was going on with Mr. Jenkins. Is that right?
Yes.
Okay. So you and Mr. Clark were conducting essentially a mini investigation at that stage into Mr. Jenkins. Is that correct?
I suppose putting it like that, yes.
Yes. Okay. So it then led to the Clark advice that deals with Mr. Jenkins. I'm going to ask for that to go up on the screen, please. And that is POL 40 6357. And can we have paragraph 38 at page 13, the bottom half? Page 13, paragraph 38, please. Okay. Now, this says at paragraph 38, the reasons as to why Dr. Jenkins failed to comply with this duty are beyond the scope of this review. The effects of that failure, however, must be considered. I advise the following to be the position. Dr. Jenkins failed to disclose material known to him, but which undermines his expert opinion. So that is basically saying that Mr. Jenkins, Dr. Jenkins says here, deliberately failed to disclose material that he was aware of. Do you agree?
Yes.
Right. This failure is a plain breach of his duty as an expert witness. And then it goes on to say, accordingly, Dr. Jenkins' credibility as an expert witness is fatally undermined. That's what it says. Do you agree?
Yes.
Right. Okay. Now, at this stage, therefore, you're considering the question of someone who has knowingly misled the courts. Do you agree?
Yes.
Right. What criminal offences has been committed if those facts are correct?
Well, perjury, potentially.
Right. Anything else?
Perverting the course of justice.
Right. So let's go with perjury and perverting course of justice. Let's ask the basic question. Why didn't you call the police?
I don't know.
nowhere in the Clark advice dealing with Mr Jenkins does anybody suggest that maybe we should just call the police and bring them in to conduct an independent investigation. Do you accept that it's not in that advice?
I do accept it's not.
Do you accept that it's not in any other advice that relates to Mr Jenkins, that maybe it might not be a good idea to call in an independent investigation, i.e. the police?
No, I just don't think that's anything we thought of.
Right. And at the time, after having conducted the investigation involving Mr Jenkins, including the taped call, did you not consider yourselves then to be witnesses in relation to what had happened regarding Mr Jenkins?
I didn't think of that, no.
No. Do you accept that you are witnesses in relation to what happened to Mr Jenkins and those calls and that investigation?
I do, yes.
Yes.
No, putting it that way, I do, yes.
Well, putting it that way is all fairly obvious, Mr Smith. When considering your position as a witness, do you think it was appropriate to continue acting on behalf of the Post Office in relation to these matters?
I didn't think of it in that way.
Well, what do you think about it now?
I can very much understand your point.
Do you agree with it?
I'm not sure I do,
Okay, why not?
because the fact that we've become aware of this information, we've mentioned it to our client, and we are then assisting our client to move on in terms of looking at cases, reviewing files, and looking for a new expert.
But not calling the police. What did you tell Fujitsu?
I don't believe we said anything to Fujitsu.
Mr Jenkins is employed by who?
Fujitsu.
Yes. And you come to the conclusion that Mr Jenkins has misled the courts dishonestly. What did you not consider it might not be a bad idea to tell Fujitsu about their employee?
I didn't give it that any thought. Perhaps I thought that Post Office might do that, given that they are the ones with a contractual relationship with Fujitsu.
It didn't cross your mind or Mr Clark's mind, as far as you're aware, to perhaps tell the Post Office that it ought to tell Fujitsu that they're, on your view, that their expert has been dishonest with the courts?
No, I don't believe. No, myself and Mr Clark did not discuss that. We didn't discuss the fact that we were potential witnesses. We did not discuss the possibility of informing the police or Fujitsu.
Right. Now let's deal with the shredding advice, also penned by Mr Clark. Now the shredding advice came about because what had happened was that you had learnt from Jarnail Singh in a conversation again you recorded that Mr Scott, head of security at Post Office, was suggesting that minutes should not be kept, otherwise they might be disclosed. Do you agree?
I don't agree fully with what you've said. It wasn't an entirety of the phone call that was recorded. It was just the latter part that was recorded.
But that was a thread of what was in the shredding advice.
It was the shredding. If we're going to call it the shredding advice, contained information
Yep.
relating to that call, and also as a byproduct of some of the Wednesday morning calls.
Yes, the shredding advice does not record that there was also a comment made to Mr Singh and reported to you that what was going to happen was that Cartwright King were going to be blamed for destroying documents. I read from your statement. Paragraph 45, page 12. My recollection at the present time is that Mr Singh alleged that John Scott had indicated an intention to shred the minutes and to explain, if asked, that they had been destroyed on the advice of Cartwright King. And you repeat that in relation to the same conversation at paragraph 52, page 14. Now, the shredding advice does not record the fact that essentially Mr Scott was apparently willing to blame Cartwright King for shredding of evidential material. Why does it not record that?
I don't know.
Is it not a serious accusation
It is, yes.
and a serious suggestion to be made in relation to a firm of solicitors?
Yes.
Did you tell the partners of the firm of Cartwright King?
I would have reported it to Mr Cash, undoubtedly, who
Yes.
is the partner in charge of the Derby office. I can't recall precisely whether I spoke to the other partners.
Well, what was Mr Cash's reaction? Was he delighted?
I don't think anyone was particularly
Right.
delighted about that suggestion.
By this point, in July of 2013, do you agree that you and the firm of Cartwright King were hopelessly conflicted in relation to your dealings with Post Office?
I don't think that crossed our minds.
Did you take any advice on that?
I just simply reported what had happened to Mr. Clark, and that was it, really.
Were these advices privileged, Mr. Smith?
What do you mean by that?
You understand what privilege is. It's the duty of confidentiality
Yes.
that exists between lawyers and clients.
Yes.
And it allows for a lawyer to advise in private a client. Were the contents of these advices, in other words, you discovering via a mini investigation with Mr. Jenkins that he apparently, on what you know, has misled courts, is that privileged material, Mr. Smith?
I'm really not quite sure.
And what about the shredding side of things? The fact that John Scott, head of security at Pole, was both threatening Cartwright King and suggesting that evidential minutes should be destroyed. Is that privileged, Mr. Smith?
No, that's not.
No. No further questions.
Thank you, Mr. Steen. We'll now have our break. Mr. Blake, can you ask the transcriber whether she requires 15 minutes or whether 10 minutes is enough? I'm comfortable with either.
She would like 15 minutes, sir.
Fine. So we'll start again at 3:20.
Yes, thank you very much.
Fine, thank you.
Thank you, sir. We're now going to turn to Mr. Henry.
Mr. Henry, I think you've asked for 5 extra minutes, so 20 to 4.
Thank you, sir.
Yeah, fine.
Thank you very much, sir. Could we go to POL 001 39866? And these are notes that you took of a meeting with Mr. Brian Altman, correct?
They are a typed version of the notes that I took. I wasn't
Fair
typing
enough,
during
but
the
you
meeting.
accept they are your notes?
Yes, I typed these.
Thank you. You'll remember, of course, that this was the conference where Mr. Altman advised that there was no positive duty to seek out individuals pre the 1st of January 2010, correct?
Yes, that's correct.
Could we go to page 3 of these notes, please? And do you see the word Susan? That stands for Susan Crichton.
Yes.
Better to keep Fujitsu on OS outside, given not resolved GJ Gareth Jenkins situation.
Yes.
And then the QC says, tactical point of view, keep them as third party.
Yes.
So in other words, keep them at a distance, correct?
Yes, I'm not quite sure in what context that is, but yes, that's the reading of it.
Well, I mean, you must surely have reflected upon this. When did you realise you were going to become a witness in this inquiry?
No, what I mean by that is I'm not sure whether that is in relation to the provision of information from Fujitsu.
It was better to keep Fujitsu on the outside, given not resolved the Gareth Jenkins situation. I'm not going to waste my 20 minutes by waiting for an answer. Shall we move on to page 6, please? And do you see just at the bottom of the screen, QC, MISRA concerned, pre-Horizon Online case, issues were as detailed as I've seen. She went to prison, Jenkins gave evidence, training and Horizon issues, Professor McLaughlin, much of it hypothesis. That is a case slipping through the net.
Yes.
You realise, of course, that I am sitting next to Mrs. Seema Misra today.
I didn't realise that.
Yeah. And you would agree that she's owed the truth.
Yes, absolutely.
Right, so I'm going to ask you some questions. Miss Crichton says, she comments that she has applied for mediation, and then the QC says, how are we going to deal if she comes forward and says similar? You see that?
Yes.
So she's got to come forward. No one's going to tell her. That was the gist, wasn't it? How are we going to deal if she comes forwards and says similar? It's obvious. She's got to come forward. The impetus is on her. No one is going to tell her.
Well, it leads into the next sentence, doesn't it?
Precisely.
Susan, either review all pre-2010 cases or we do nothing and wait for them to come forwards.
Exactly. And that's precisely what occurred.
Yes, I think what occurred was that there was a decision to review cases which commenced after the 1st of January 2010, that being the earliest date upon which Horizon Online could have been in place. But I think we changed that so it was any case with a hearing after the 1st of January 2010, which of course then included Mrs. Misra's case.
Well, we'll come to how you deal with it, but I note your apparent justification for the decisions taken at this conference and subsequently. But it seems at this stage, no one wanted to provide Mrs. Misra with a ticket, to use your expression, to the Court of Appeal. Do nothing, adopt a passive approach. Correct?
I would certainly agree that the Post Office did not want at that stage to be actively encouraging people to go to the Court of Appeal.
No. And you know why that was, don't you?
I take it you're going to enlighten me.
Oh, come on. Must we play games, Mr. Smith? I'm sitting next to a lady who was the foundation stone for the prosecution policy. Her case was a test case which was used to deter civil claims and criminal defences. The conviction obtained against her was absolutely seminal in the whole prosecution policy. You must have realised that.
I was aware that Mrs. Misra had been prosecuted. I think at the time of this conference, I don't think we had seen her file. I think we were being told that her file was not available. It couldn't be found. And I think the first time her case was reviewed was, I think, by Mr. Clark having to read the judge's summing up to the jury. And I think that was also provided to Mr. Altman, King's Counsel, and I think he commented that a particular page was missing. It wasn't until quite some time later that the case file relating to Mrs. Misra was discovered and provided.
Right. Can I just ask you, please, to keep your answers short, because they're eating into my time and I've got quite a lot of things to put to you.
I do apologise.
Right. I'm going to go and ask you this question. In view of the answers you've given to Mr. Steen, King's Counsel, and in view of what you already knew by this time, namely the 28th of June recorded conversation, the 15th of July advice, why wasn't Mrs. Misra immediately being told?
I don't know.
Well, I suggest the reason is obvious, and it is going to be clear from the evidence that you've already given to Mr. Blake. It is because of the fact that if disclosure had been made to her promptly, it would have, as it were, set off the domino effect, wouldn't it?
I don't think that I gave any thought to that whatsoever.
Well, you have spoken, haven't you, about how you were concerned, how the civil lawyers, Roderick Williams, Mr. Parsons, etc., the civil lawyers appeared to be exerting pressure, talk of suppressing disclosure, talk of not putting things in writing, etc., etc., etc.
In civil litigation.
But of course, if Mrs. Misra's appeal was promptly notified to her, an irresistible appeal, you surely don't dissent from that judgment.
No, I think the plan of action was that all cases should be reviewed, and they should go through the civ process. Then senior counsel would conduct a full review to determine whether disclosure should be provided. And that is precisely what happened in relation to Mrs. Misra's case. I'm afraid I don't recall having any particular involvement with Mrs. Misra's case.
Well, we'll come to that. It seems you agree at that stage that you didn't want to provide Mrs. Misra with a ticket to the Court of Appeal. And then these words, that there may be Misras, other Misras, we can't avoid, this is the QC, provisional view, sensible date to adopt, in other words, the 1st of January 2010, but can't avoid possibility Misras may crawl out of woodwork, deal with on a case-by-case basis unless someone states cut-off is unreasonable. In other words, do nothing pre-2010, but some applicants may yet emerge, deal with them ad hoc, unless someone challenges the 2010 cut-off as being unreasonable. You agree with that?
That was Mr. Altman King's counsel's advice, yes.
Right, let's go to Mr. Matthews, page 7, please.
Before you go there, Mr. Henry, and
Certainly, sir.
And I'll give you an extra minute because I'm interfering. What does Misra unique mean, so far as you're concerned, Mr. Smith? You see just a couple of lines down from where the point Mr. Henry took you.
I'm afraid I have no idea, sir. I've got no idea.
Let me jog your memory. It's because it's the only case in which Mr. Jenkins gave oral evidence against a defendant, although he had given written evidence. That's why she was unique.
That may be the case.
Right. Go to page 7, if we may. And Mr. Matthews says, Misra, apologise. And the QC is reported to have said, I wouldn't. You wouldn't have written that down if that wasn't accurate, would you,
No.
Mr. Smith?
No, I wouldn't.
No. Because, of course, an apology would let the cat out of the bag. It would let the Jenkins cat out of the bag. So, therefore, there was an approach of do nothing, masterly inactivity. Correct?
I don't believe that Mr. Jenkins was discussed in relation to this.
Well, what would you be apologising for? What would the apology for Mrs. Misra be for if it weren't to be in connection with the fact, oh, I'm sorry, we secured your conviction on the basis of an expert who did not know his duties to the court and who may, on the information that we have on tape, suppressed vital information about bugs, errors and defects. You know, even Mr. Matthews thought that maybe that deserved an apology, didn't he?
I think this may have been discussing the way in which her mediation application may have been dealt with, and
well, I can deal with that in very short order because Mr. Altman said don't mediate with her, didn't he?
well, he was against mediating with anyone who had a conviction.
Yeah.
He was very clear in his advice in relation to that.
Yeah. As we can see on page 7, see mediation for anyone who is outside scope of criminal scheme. I think storing up problems is a phrase I underline. Is she considering out-of-time appeal? That must be a reference to Mrs. Misra. You agree?
I do agree, yes.
Page 8 of 11. No problem with mediation, however, do have a problem with someone going convicted to the scheme. My view is storing up problems with Misra. So his clear and unambiguous advice was don't mediate with her.
Yes, that's correct.
Foot of page 8, please. And do you see foot of page 8, please? Yes, we got it. 5 lines up from the bottom. At the moment, on the right lines, just control it. That's again Mr. Altman speaking, isn't it?
I believe so, yes.
Yeah, and of course that echoes the Altman General Review at paragraph 129 that Mr. Blake took you to this morning, where Mr. Altman writes, Cartwright King wished to exercise a measure of control over the dissemination of information and material during the process. So this is where, I suppose, Mr. Altman is basically saying, yes, keep a vice-like grip on disclosure. Correct?
He was advising to be very careful what was disclosed, yes.
Keep a vice-like grip on disclosure. Keep it tight.
I don't recall the words vice-like grip being mentioned.
Well, he didn't want anything to be loose, did he?
I think his view, well, as I understand his view, he was very much of the view that a casual comment or a throwaway comment or even an apology could actually have substantial ramifications for Post Office.
Right. Now, I want to understand now, in the remaining minutes that I have, how a decision was taken on the 5th of December 2013 when the firm said, and it was the firm, that Mrs. Misra should have disclosure, because on the 5th of December 2013, POL 001 98595, and it's a matter of record, it's paragraph 33 of that document. It is our view that this case clearly passes the disclosure threshold, and we will be disclosing the Second Sight interim report and the Helen Rose report to Misra's lawyers. It should be said, however, that the defence were aware of the Falkirk defect in this case, and it was discussed in the trial. This is the only pre-Horizon online bug of which we are aware. So 2 questions arising out of that paragraph. Who wrote that paragraph?
What's the name at the bottom of the document?
Cartwright King.
Cartwright King. Well, it certainly wasn't me who wrote that paragraph.
You were involved in the preparation of this document. You say so in your statement.
Yes.
Can you not tell Sir Wynne, the chairman of this inquiry, to the best of your recollection, who wrote that paragraph?
If it just simply says Cartwright King at the bottom of the document, I would guess that that was written by Mr. Bowyer, because Simon Clarke would generally sign off his paragraphs, sign off his documents, Simon Clarke.
I see. And so I now ask you this question. Why was Mr. Bowyer taken off this matter? Because on the 22nd of January 2014, Mr. Clarke sent you an email which had the full review of the Seema Misra case, draft document, and he said one word in that email to you when he sent it to you. It was "phew!" triple exclamation mark. Who took Harry Bowyer off the case and put Simon Clarke on it?
I'm not aware that anyone took Harry Bowyer off the case.
Well, why didn't Mr. Bowyer, if he wrote paragraph 33, have continuing control of the matter? Why was it that on the 22nd of January 2014, Mr. Clarke sends you an email with the word "phew," attaching a document which says that Mrs. Misra shouldn't have any disclosure.
I don't recall that.
And you responded to it as one complex matter ends, another starts. You were in on this, weren't you? Tell us the truth. Why did the firm do a complete backflip somersault on whether Mrs. Misra's team should get disclosure?
No, I don't recall appreciating that there was a complete somersault.
Are you being serious, Mr. Smith?
I am being serious with you. Yes, I'm being deadly serious with you. I remember that the initial review of Mrs. Misra's case was a partial review based on the judge's summing up, and then Mr. Clark looked at that, and it would appear from what you're saying that he then reached that decision. I'm afraid I can't add anything more to that.
Can we go back to first principles? 28th of June, 15th of July, expert witness credibility facially undermined. If Mr. Jenkins had given evidence either orally or in writing against any defendant, the material that you had from the 28th of June and the 15th of July was material that would cast doubt upon the safety of any conviction associated with his evidence, wouldn't it?
I agree with that now, yes.
You should have agreed with it then, and you did agree with it then, because of the 5th of December 2013 document that went out in your name, saying that she ought to have been given disclosure. What happened between the 5th of December 2013 and the 24th of January 2014? Tell the truth.
I have got no idea. As far as I was aware, Mrs. Misra's case was being looked at in accordance with the protocol. I'm speculating, but it may be that by the time Mr. Clark had looked at it again, we perhaps had more information.
You were in daily contact, you told Mr. Blake, with Jarnail Singh.
Almost daily.
Again, I put it to you that if Mrs. Misra's lawyers had been given prompt disclosure, the whole prosecutorial facade of Horizon's reliability and infallibility would have collapsed, wouldn't it?
Her case was assessed by Mr. Clark, who, as you've said, concluded that no disclosure was necessary.
We know that,
was
but
made to
the
other
reason
people.
why he said that, I suggest, is because somebody obviously put pressure on him because of the ramifications Mrs. Misra's inevitable appeal would have had for both civil and criminal litigation.
Well, that's, with respect, that's nonsense, and it certainly wasn't me.
Why is it nonsense?
Well, I've not put any pressure on Mr. Clark. None at all.
And you can offer no explanation at all for Mr. Bowyer not continuing with carriage of the matter and that fundamental shift between the 5th of December 2013 and the 24th of January 2014, or forgive me, the 22nd of January 2014. You can offer no explanation.
No, all I can think of is by that time it may be that we had more information, because to start with, as I've already said, there was very little information available, and then I think the file was then discovered and sent through. Now, how that fits into the timescale, I'm not sure. But
I'm afraid that your assumptions here are incorrect, as would be clear if you had read the 22nd of January advice. I ask you for the final time, and my time is up, what is the truth about the firm's shift between Mrs. Misra should get disclosure in December 2013 to Mrs. Misra ought not to get disclosure under any circumstances on the 22nd of January 2014?
I cannot give you any information in relation to that. All I can suggest is that you ask Mr Clark as to how he came to his conclusion.
Thank you, Mr. Henry. Right. I think the final series of questions comes from Ms. Oliver.
Thank you, sir. Mr Smith, I ask questions on behalf of Gareth Jenkins. I hope you can just about see me.
And for the avoidance of doubt, your time limit is 4:05, Ms. Oliver.
I'm grateful. Thank you, sir. I have 3 topics that I want to cover with you this afternoon. Firstly, the question of expert duties. Secondly, the call that you conducted with Mr Jenkins in relation to the case of Samra. And thirdly, a discrete element of your treatment of Mr Jenkins in the case of Ishak. All right, so to turn to the first of those then, you have very candidly accepted that at the time you were prosecuting these cases, you were not aware of your duties in instructing and deploying expert evidence. Is that right?
That's correct, yes.
And following what you said, that it's difficult to follow something of which you are not aware.
Yes.
You also candidly acknowledged that Cartwright King never instructed Mr Jenkins in a compliant manner and never told him about the expert duties to which he was subject.
That's also correct, yes.
Thank you. The way you deal with that in your second witness statement, I don't think we need to go to it, it's paragraph 21 of that statement, is that you state Mr Jenkins should have been given detailed written instructions in relation to each individual case, which enclosed a full set of papers, asked specific questions, and set out the duties of an expert instructed by the prosecution. Mr Jenkins had not been so instructed. Is that correct?
Yes, that's right.
In that paragraph 21, you don't specify between Cartwright King and Post Office in terms of their instructions. Did you come to the same conclusions as to the non-compliant instruction of Mr Jenkins in relation to Post Office's use of him in the prosecutions they conducted before Cartwright King became involved?
I'm sorry, I'm struggling to see you.
I know.
There we go.
I'm going to come this way. Hopefully that will be easier.
Oh, no, I'll go back that way.
Thank you.
Okay.
That's very kind of you. Thank you.
I took the view that it became apparent to me, following the provision of Mr Clark's advice, that we had not been compliant in terms of instructing Mr Jenkins. Mr Singh, who had followed Mr Bowyer's advice, had not been compliant in instructing Mr Jenkins, and of course Mr Singh was head of criminal law at Post Office, and in the circumstances I was quickly coming to the view that actually when the Post Office was part of the Royal Mail Group, it was highly unlikely that he had ever been advised of his duties then either. Otherwise, even though there was a requirement to advise him on each occasion, which I was unaware of, it occurred to me that he'd probably never been advised at all.
Thank you. So the answer to my question then is that it did relate both to Cartwright King's instruction and to Post Office's.
Yes.
Thank you. Do you agree that that was a serious failing on the part of Cartwright King and Post Office in the manner in which they conducted these past prosecutions?
It was a serious failing in terms of how they obtained expert advice.
Thank you. And do you agree that it's particularly important because it goes to the very failing that Mr Clark identified in his advice of the 15th of July 2013, by which I mean the failure to disclose material in accordance with those expert duties?
It does go to that, yes.
Thank you. I think you said in answer to my learned friend for counsel to the inquiry that you knew of that failure, certainly in relation to Cartwright King, at the time that Mr Clark was producing the advice of the 15th of July. Is that right?
It was that advice which really drew my attention to it.
Is it something that you discussed with Mr Clark at the time he was writing that advice?
I don't recall discussing it with him.
Are you aware of whether he was aware of that lack of expert instruction at the time he was writing his advice?
I don't know.
Thank you. Can we please go to a document? It's POL 001 55 555. Thank you. This is a handwritten note. You can see the date in the top right-hand corner. It's the 2nd of September 2013. We've heard evidence that this was a note authored by Roderick Williams of Post Office. It appears to refer to you at a number of points. I'm just going to identify those for you. About halfway down the page, we can see it seems to be the words tell to MS. Do you see that?
Yes.
And then if we scroll down a little bit further, please, we see on the left Martin Smith and then the word inference, and then a few lines down, M. Smith. Do you recall having a conversation around this time with Mr. Williams?
No, I'm sorry, I don't.
All right. If we go to some of the things he records that might jog your memory, on the right-hand side of the page we have in front of us at the moment, in the box, it says, what were we doing to instruct GJ? And then on the left of the page, under the words M. Smith, are a number of arrow bullet points, the first of which is don't think he's ever been advised of his duties. Do you think that this note might be recording a conversation that you had with Mr. Williams?
It's quite possible, yes.
And do you recall whether during a conversation you had with Mr. Williams, you informed him of your view that you've informed us of this afternoon, that you don't think Mr. Jenkins had ever been advised of his duties?
I can't recall the conversation, I'm afraid.
All right.
It's such a long time ago.
Do you recall being party to any other discussion with anyone within Post Office as to the conclusion you'd reached that Mr. Jenkins had never been properly instructed as an expert?
No, I don't.
And if, as this note appears to indicate, you were having that sort of conversation with Mr. Williams, does that make it more likely that that's a conversation you would have had with Mr. Clark as well?
I may have had that conversation with Mr. Clark, but I can't say it makes it more likely. I just don't know.
All right, thank you. Can we please turn to POL 001398666? This is your typed note of the notes that you took during a conference with Brian Altman QC on the 9th of September of 2013. If we could go to page 4, please, about halfway down. And it's the entry, thank you, that starts Simon, and then it says, goes back to GJ, either he not aware of info or FJ Ivory Tower not being taken seriously. Do you recall what that comment from presumably Simon Clark referred to?
Yes, I can recall that there was a discussion about Mr. Jenkins. And I think I actually wondered whether he'd actually become aware in a timely fashion of the various bugs himself. And according to this note, Mr. Clark's view was either he wasn't aware of the information, or alternatively that FJ, meaning Fujitsu, was in an ivory tower and not taking their obligations seriously.
As part of the discussion about Mr. Jenkins that appears to have featured in this conference, did you at any point tell Brian Altman QC of your conclusion that Mr. Jenkins had never been instructed in a compliant manner and had never been told about his expert duties?
No, I don't think that occurred to me.
All right. Can we please turn to the Simon Clarke advice? It's poll 00006357. And can we go please to paragraphs 37 and 38, which I think are on page 13. Thank you. So there we see at paragraph 37 the conclusion that I've already referred to, that Dr. Jennings, meaning Jenkins, has not complied with his duties to the court, the prosecution or the defence, and it sets out the expert duty of disclosure there. And then at paragraph 38, the reasons as to why Dr. Jenkins failed to comply with this duty are beyond the scope of this review. Do you know why those reasons were considered beyond the scope of this review?
No, I don't.
Is it because the reason it appeared you knew at that point, at the very least may have been, and by the reason I mean the reason for Mr. Jenkins' failure to comply with that disclosure obligation, may have been that he was never told about the very duty he was accused in this advice of breaching?
I think Mr. Clarke was concentrating on the effects of the failure, not the method of instruction, because we knew at that stage that Mr. Jenkins had been instructed, obviously, for quite some number of years, whereas Cartwright King had been involved at that stage for approximately 1 year.
Well, all of the statements that Mr. Clarke refers to in this advice concern statements obtained by Cartwright King.
Yes.
All right. So that's certainly the focus of his
I believe
discussion.
I handed them to him.
All right. But did you not think it relevant, the manner in which Mr. Jenkins had been instructed of the expert duty that he was accused in this advice of breaching?
No, I didn't give that thought, I'm afraid.
On any view, do you agree that what you discovered about the lack of instruction of Mr. Jenkins was a hugely relevant factor, hugely relevant material to anyone who was looking at the conduct of past prosecutions, whether that be Post Office or Cartwright King?
I can see that now, but I didn't think about that at the time.
Do you agree that that conclusion that you had reached as to the lack of Mr. Jenkins' instruction ought to have been communicated to Mr. Altman, to Post Office, to the CCRC?
I'm afraid I didn't think of it in that level of depth.
Is the reason why there was a lack of openness about that conclusion that you had reached because it would have been professionally damaging to Cartwright King to make that concession?
No, I just didn't think of it in that way. I mean, I was looking at it. In fact, this is where we are now. We have these reports. They didn't mention bugs. What are we going to do about it?
And had it become known, Mr. Smith, that there had been that acknowledged failure on the part of Post Office and Cartwright King, that would have led to an obvious conflict for your firm continuing their involvement in reviewing those past prosecutions, wouldn't it?
I didn't give that any thought, I'm afraid.
All right.
I just simply thought, as a matter of fact, well, I'm not, we certainly haven't provided that level of instruction which Mr. Clarke has referred to, and I don't think Post Office did either, or the Royal Mail Group for that matter. That was simply my thought process.
And is the relevance of that failure to the conclusions of Mr. Clarke simply something you didn't recognise at the time?
I just didn't think of it.
All right, let's turn to my second topic then, please. I'm wary of the time. If we can just look at the transcript of the call in relation to SAMRA. It's poll 00142322. It's right, I think, that on the 28th of June 2013, you and Mr. Clark made a telephone call to Mr. Jenkins.
Yes.
Is that right?
That's right.
How was that recorded?
I don't recall precisely how it was recorded.
Do you recall how this note was produced from that recording?
No.
Do you recall who prepared it?
No, I don't.
Do you recall when it was prepared?
No.
Do you agree that Mr. Jenkins was given no warning about this call?
I do, yes.
Do you agree that he had no prior knowledge of the case of Samra?
I don't believe that he would have known about the case of Samra because I don't believe any form of expert report had been sought in relation to that case, so he wouldn't have had any instructions, whether defective or otherwise.
And you acknowledged to my learned friend Mr. Steen that you were at this stage suspicious in relation to Mr. Jenkins. Is it right that this call was to test Mr. Jenkins' credibility, as you and Mr. Clark saw it, by seeing if he would agree that he had provided information to Second Sight about the receipts and payments mismatch bug and the suspense account bug?
I'm not sure if the call was to test his credibility. I think Mr. Clark just wanted to speak to him to try and get some information to determine how to proceed with the case against Mrs. Samra.
And what information was he hoping to obtain?
I don't recall.
If the call was being recorded, Mr. Jenkins was not told that.
He wasn't told that, no.
And he was given no chance to check the note for accuracy or understanding as to what he had said?
No.
All right. Turning then to the third and final topic that I want to address. You, to a degree, had conduct of the case of Ishak, is that right?
To a degree, yes, yes. I think it got passed around quite a bit, and towards the end it was very difficult to follow with a number of people who had involvement.
Do you recall that at a certain stage in that case, Mr. Jenkins was invited to comment on the first defence statement that Mr. Ishak had produced?
I do, yes.
And if we can please go to Pol 001 19447. Please. We see here an email from you on the 4th of February 2013 forwarding Gareth Jenkins' comments on Ishak's DCS to Mark Ford and Steve Bradshaw. Do you recall reviewing those comments that Mr. Jenkins had made on the defence statement?
I don't recall reviewing them, I'm afraid, but I guess I must have done.
Thank you. And if we can go to the comments that he made, please, which is Pol 000 59602. Thank you very much. Here under Section 1, Introduction, Mr. Jenkins says, I've been asked to comment on the defence case statement in the case of R and Khayyam Ishak. And then he states, I'm not sure that the responses are of much use, and I don't think there is anything that can really be added to my statement as a result. However, if you feel any of this could be usefully added, I'm happy to be convinced. Much of it relates to requiring further data for analysis, and past experience indicates that help may be required in understanding it. So he's referring there to the fact that there's data that might be obtained that would assist in the preparation of the case. Do you agree?
Yes, he's talking about data that can be analysed, and also talking about the fact that the defence may not necessarily understand it. So he's saying that he could assist the defence.
Thank you. And then if we can please go to page 2. And under number 7, part of the nature of the defence is set out in relation to Post Office Horizon software hardware system malfunctioning. And he says, if the defence can specify some examples of this, I am happy to investigate them. However, I would contend that the system doesn't malfunction without leaving some trail to indicate what has happened. Without examining the logs, it is difficult to be any more specific. Do you interpret that as another reference to the ARQ data that could be obtained in this case?
I think I'm not sure if I understood it to be the ARQ data, but I thought that data had been obtained in this case.
Well, data had been obtained in this case, you may remember, and provided to the defence, but was never provided to Mr. Jenkins. Do you agree? Do you remember that?
No, I don't recall that, and I think we were potentially of the view that with Mr. Jenkins being at Fujitsu, he could quite easily look at the data that Fujitsu held.
Did you not understand that he was reliant on Post Office in order to obtain the ARQ data?
No, I don't think I was.
All right. If we can go to page 4, please. And subsection 6. This is the defence request for all Horizon system data for a particular period of time. And Mr. Jenkins states, I assume that this is the data returned in the ARQs by Fujitsu to Post Office Limited. I have not seen this, but would be happy to examine it if required. When you saw these comments from Mr. Jenkins and the repeated offer to look at the ARQ data, why was it that you did not ensure he was provided with that underlying data?
I was under the impression that he had the data.
Well, we know that, in fact, he is never provided with the data and he tries to obtain it for himself on the eve of trial. Do you recall that?
No, I'm afraid I don't.
Do you agree that in these comments Mr. Jenkins is indicating that system malfunctions are possible and could be looked for in the logs?
Yes, and he's also inviting the defence to supply some examples, which is indeed what I was trying to do as well.
And that he's saying he cannot be more specific unless he has examined those logs?
Yes.
Thank you. Those are my questions.
Thank you, Ms. Oliver, and thanks to all the legal representatives of core participants for their discipline in keeping the time limit. That's it, is it, Mr. Blake? There are no further questions.
That's correct, sir.
So thank you, Mr. Smith, for providing 2 detailed witness statements to the inquiry and for answering questions over yesterday and today. I'm grateful to you.
Very well, thank you.
And we'll resume at 9:45 tomorrow morning.
Yes, sir, with Mr. Singh.